Penal Code Section 287 is oral copulation of a minor, formerly known as Penal Code Section 288A. Now, oral copulation of a minor is any contact, no matter how slight, between the mouth of one person and the sexual organ or anus of the other party. Penetration is not required for an oral copulation charge, and consent is not a defense if the person was a minor. Now, to be found guilty of a violation of Penal Code 287, subsection B, subsection 1, or oral copulation, the prosecution must prove two elements. First, they have to show that you engaged in some kind of act of oral copulation and that the person you engaged with in this behavior was under the age of 18. Now, this is important because, as I indicated, consent from a minor is not a defense to the charge. Consent requires a person to be 18 years old to give legal consent. A person under 18, although they might factually consent to the conduct, cannot legally consent under the law. Now, a common example of this is high school relationships. You have a senior who's 18 dating another senior who happens to be 17. Now, if at any point in time they engage in any kind of sexual conduct, such as oral copulation, then that 18-year-old can still be found guilty of a Penal Code 287 violation. This doesn't matter if they're in a relationship, and it doesn't matter if the parents even consent to the conduct. All that matters is that the one party is 18 and the other party is under 18 and the sex act occurred. Penal Code 287 is a wobbler offense in that you can be charged with this as a misdemeanor or as a felony charge. If you were charged under Penal Code 287 as a misdemeanor, you could face upwards of 1 year in county jail. If you are charged with violation of Penal Code 287 as a felony, you could face upwards of 16 months, 2 years, or 3 years in a state prison. You would be required to serve 50% of that time in custody. Now, a violation under this section is also not a strike. However, any conviction, whether it be a misdemeanor or a felony conviction, will result in a requirement for you having to register as a sex offender for life under Penal Code Section 290. Now, the circumstances change even more so if you are over the age of 21 and the minor is under the age of 16. In that situation, you could still go to prison for up to 3 years. However, it is not a wobbler offense. It is a straight felony violation. Further, if the minor is under 10 years of age, you could be sent to prison for upwards of 12 years. Now, there are several defenses to a violation under Penal Code 287. There can be statute of limitation issues. There can be issues with insufficient evidence, violation of your rights, as well as a mistake of fact or a reasonable good faith belief or mistake as to the age of the victim. Now, what that means is this is one of the rare cases in sex crimes where if you are under a reasonable and good faith belief that the person that you are engaging in this sexual activity with is actually an 18-year-old or older, then that acts as a defense to the charge. Understand, though, that this reasonable belief has to be reasonable. Therefore, if the minor looks obviously 12 years old, mentions things like they go to middle school and that school is hard, and certain other indicators and circumstances that a reasonable person would believe that this person is not actually 18 years of age, then in that case, the defense would not apply to you. These are extremely scary times. With the thought of prison and sex registration for life lingering over you, you need to find an experienced and knowledgeable sex crimes attorney to help you. Call the Inland Empire Criminal Defense today, and I can help you.